Good afternoon, everyone. I'm Jeff Furby. I'm an assistant city attorney. I work for Zach Klein. I'm assigned as chief legal advisor for the Division of Police. I've been in that role for a long time, almost 20 years, I think. Before that, I was a civil litigator where I handled lawsuits in federal court largely. And before that, I was a prosecutor. Alexis, you want to say hello?
Yes. Hi, my name is Alexis Dorsey. I work with Jeff as assistant police legal advisor. I just came over from the county prosecutor's office. I was there for about 7 years prior to coming over here in October. And so over at the county's office, I started in juvenile, then went to grand jury where I was reviewing cases and presenting those cases to the grand jury for indictment, and then went to trial staff with just regular trial staff, and then I did about 2.5 years with the special victims unit, dealing with those cases, and then briefly going back to juvenile before coming over to the city attorney's office.
So you'll be seeing both of us down the road. So a little bit about what we do. We basically function as in-house counsel with the Division of Police. We give 24/7 legal advice to the division and to division police officers. A big part of that is legal training as well. We do all legal in-service training and all recruit training. The recruits, we spend about 60 hours or so with each recruit class, primarily teaching arrest, search, and seizure, which is Fourth Amendment issues, which is mostly what we're going to talk about today. We do in-service with officers every year. Last year, we spent 5 hours with every officer. It takes about 50 to 60 classes done over and over to see every officer in person. And again, that's almost all arrest, search, and seizure, almost all Fourth Amendment stuff. Again, what we're going to talk about today. The vast majority of questions we get from officers are arrest, search, and seizure or Fourth Amendment questions. And that's the vast majority of what we're going to talk about today. And I think probably, a huge percentage of complaints or for lack of a better phrase, negative police-citizen interactions relate to Fourth Amendment issues. So that's what we'll talk about. As I go along today, feel free to ask questions. I have a script I'm going to follow. I wasn't sure how much you'd have questions, so I wanted to make sure we used our time. But also, if you want to stop me and ask questions at any point or ask Alexis questions, feel free to do that. We're here to try to, explain some of these issues as they relate to the police. So what do I plan on talking about today? I want you to understand how CPD officers are trained legally. I want you to understand what are the current issues or trends with arrest, search, and seizure. We're going to talk about relevant newer case law. So that's what we're going to try to do today. And Ms. Burns has also sent me some issues she wanted us to speak about specifically. They're mostly tied into the stuff we were going to cover anyway, so I think we can weave those in. If I forget something, feel free to tell me that. A couple of things as I start this, and I say this to every group I talk to. Being a police officer is difficult. I think being a good police officer is very hard. We expect officers to know a lot of law, and to apply it quickly in stressful situations. It's not an excuse for our officers. It's not an excuse for bad behavior, violating policy or the law, but it is the reality that we expect them to know more and more legal issues and know them quickly. So I always try to stress that. I've given you a number of handouts. There's an outline for today that's about 10 pages long. I'm not going to talk about every bit of that, but I wanted it in front of you. I've also supplied you 2 of our legal updates. Ms. Burns had asked that I bring those. It kind of shows what we send out to officers. We do legal updates. I used to do them every month. It ends up not being that frequent now because we do so much in-person training, to be honest. But we still do several of those a year. We've done probably 200 legal updates over the last 20 years, and that's besides emails and other memos. One of the things I will show you is the amount of legal information being sent out to officers and the amount of legal information we expect them to know. I will say, too, officers generally like getting these. They ask a lot of questions. They follow up. They are engaging in making sure they try to understand these issues as best as they can. So going to the handout, the Civilian Review Board handout. a couple of things. And we've done a lot of training in the last year with officers, and we've done a lot of back to basics, Fourth Amendment training, to make sure that officers fully understand where most of these legal issues emanate from that cause them trouble, that cause citizens trouble. So the Fourth Amendment at the top of page 1, I don't want to be too basic, but I do want to mention this. The vast majority of policing issues emanate from the Fourth Amendment or relate to the Fourth Amendment. The Fourth Amendment was, I think, ratified in 1791. It's an awfully old document. But what the Fourth Amendment says, and we try to make this as relevant and real to officers as possible because it's really important. It says the right of the people to be secure in their persons, houses, papers, and effects. So what's protected by the Fourth Amendment? Persons, houses, papers, and effects. Now, over the last 230 years, the Supreme Court has expanded what's protected to include those things in anywhere else where a person would have a reasonable expectation of privacy. Right? And what are those things protected from? Unreasonable searches and seizures. And who does the Fourth Amendment protect citizens from? The government, which is the police for a lot of people. And we constantly talk to the police about that line. So what makes a search or seizure reasonable? Generally speaking, according to the Fourth Amendment, a search warrant supported by probable cause issued by a judge. That's the rule of the Fourth Amendment. Now, over the last 230 years, a ton of exceptions have been created by the courts to allow for better functioning of policing. But we do tell officers, this is the rule. The general rule is you need probable cause to conduct a search with a search warrant issued by a judge. Okay, that's the rule. And if you don't have that, then what exception are you within when you're doing that? And I'll kind of explain more of that a little bit later. So state first keister on the middle of page 1. When we talk about street-level policing, and obviously a lot of issues between citizens and police relate to street-level policing, you know, those interactions at street level, a lot of the times the first 30 or 60 seconds of that interaction are where we get trouble from. Our courts are going to look at every police-citizen interaction and try to put it in one of 3 buckets. It's either a consensual contact, okay, meaning the person's free to go. They're not seized under the Fourth Amendment. It's a Terry stop or investigative detention, meaning they are briefly seized based on reasonable suspicion, or it's an arrest supported by probable cause. It's always one of those 3 things. So when we look at something, as attorneys for the division, if we're looking at an incident, we're thinking, okay, what bucket is it in? And did they do it the right way? Did they do it the way you're supposed to do it in that bucket, basically? That's how we look at every interaction between an officer and a citizen. And the first one of those is consensual contacts or consensual encounters. And what you'll hear us say is consensual contacts are those interactions where the Fourth Amendment does not apply because the officer is not seizing the person. The person has to feel free to go, or a reasonable person in their position has to feel free to go for it to be a consensual encounter. State v. Ivory in the middle of page 1 is a new CPD case. It's from late 2023, so just in the last few months. It's a new CPD consensual encounter case from the 10th District Court of Appeals, which is the appeals court for Franklin County. This is a good case. It lays out the rules of consensual encounters, talks about how they work. And I can tell you right now, there are some citizens who do not enjoy consensual encounters, even when the officer is acting within the law. All right? Consensual encounters are not Fourth Amendment seizures. Officers are allowed to approach people, ask them questions, ask for their identification, ask them what they're doing. They could ask for consent to pat them down or search, as long as that person is free to go. As long as the officer doesn't send a message to that person, they have to comply. All right? So, like I said, this was a CPD consensual encounter case, and this was a case where the Court of Appeals believed the officer was too aggressive during the consensual encounter, and based on how they treated the person, turned it into a Terry stop or an investigative detention. We put this case out. It should be in the, I think, the legal update from December you have. We put this case out to officers. We give them all the facts. We give them the law. We point out the critical issues in the case, and we generally try to make some practical suggestions of how to now deal with this decision and do better policing. Consensual contacts or consensual encounters happen every day. It's officers talking to people. However, there are times that officers are having a consensual encounter because they don't have enough to detain, but they're trying to gather more facts to see if they can get to enough to detain. That's the reality of policing. The U.S. Supreme Court has validated consensual encounters as a valid police tactic. Essentially what the Supreme Court says is as long as that person's free to go, it's consensual. And here are the kind of things we think you shouldn't do that would make a person feel detained. And as long as you kind of stay within those parameters, it's a consensual encounter. This CPD case here, the officer interacted with the guy, asked him a lot of questions, and the guy made it crystal clear he did not want to talk to the officer. He kept walking away, kind of waving off the officer, so the officer kept following him and asking him questions. The officer's take on it was, well, he knew he was free to go. He kept walking away and telling me to get lost, basically. So there was nothing wrong with me continuing to walk behind him and ask questions. Our court said, well, at some point, you have to let him walk away. You can't keep following and asking questions because, in effect, you're making it clear to him he's not free to quit interacting with you. So the Court of Appeals said at some point as he walked behind him and asked him questions, it became a detention. It was no longer consensual in nature, that he should have just let him walk away freely at some point instead of following him. So we put this out to officers. We've had a lot of discussions of training about the fact that if someone makes it clear they don't want to talk to you, that interaction needs to end at that point, unless you have enough to detain them at that point. Bottom of page 1, Terry stops, investigative detentions, and we use those terms interchangeably, a Terry stop, an investigative detention, whatever we want to call it. That's when an officer has reasonable suspicion of crime and briefly detains a person in order to investigate. Terry stops have to be based on reasonable suspicion. Flipping over to the top of page 2, and US v. Fott is an interesting federal case. And I think it does tell you that reasonable suspicion for a Terry stop is not a particularly high bar. Okay. In this case, it says the reasonable suspicion test does not demand much. Okay. That's our federal court. The Sixth Circuit is the federal appeals court for this part of the country. To put things in perspective, the probable cause standard needed for a more invasive search or seizure is not a high bar, requiring only a probability or substantial chance of criminal activity. An officer needs only a suspicion that is particularized, okay, and objective under the totality of the circumstances known to the officer to stop and detain someone. So reasonable suspicion is more than a guess or a hunch, but it's less than probable cause. It's some articulable facts where the officer can say, I have some facts to believe that person's involved in crime. I'm going to stop them and briefly investigate if they in fact are involved in crime. Terry stops are supposed to be short. They're supposed to be quick. The officer should get to a fork in the road fairly quickly. Either my reasonable suspicion ripened to probable cause, or it didn't, and I let him go. They should be brief detentions. They generally should not involve handcuffs or force, generally. Right? State v. Mahone is a new case out of Common Pleas Court here in Franklin County. It's a CPD case. This is a case where the judge believed the officer had passed from a Terry stop to an arrest inadvertently. Like I said, Terry stops are supposed to be short and involve minimal force. In Mahone, officers stopped this guy. At some point, they handcuffed him, and at some point, they chose to move him to another location to be interrogated by police and fire. This related to an alleged arson. The officers acknowledged they did not have probable cause to arrest him. The court said the use of handcuffs may be reasonable in some Terry stops if you fear for your safety, but generally not. And when you move the suspect any significant distance, it is an arrest. It's not a Terry stop anymore. So here the court found that the officers had arrested him without probable cause by moving him and by how they handled him. We call these length and manner cases. Well, we tell officers on every Terry stop, and Terry stops are obviously a point of conflict. We tell them to stop someone, you need reasonable suspicion they've broken the law. And for it to be reasonable, it has to be reasonable in length and manner. Terry stops can't be too long, and you can't use too much force or move people around. All right? So when can an officer handcuff during a Terry stop? If they think the person's armed, dangerous, or a flight risk. Otherwise, they shouldn't be in handcuffs. When can they use force? Well, they can use reasonable force to effect a detention, but reasonable force. So these should be short, fairly non-invasive encounters unless the person gives an officer reason to think they may be armed or dangerous. State v. Oliver is a Whitehall case out of the Court of Appeals last year. It talks about pat-downs. Do you understand the difference between a pat-down and a search? I think sometimes police will say things like that. I patted him down or I searched him. They'll get used interchangeably, or citizens will use them interchangeably. Officers can pat down citizens during a Terry stop if they think they're armed or dangerous. If they have reasonable suspicion they're armed or dangerous. Pat-downs are of the outer clothing. Right, outer clothing, and they only are for weapons, not for contraband or evidence. Officers shouldn't be going into pockets or into things during a pat-down. It's quick outer clothing to make sure they don't have a weapon so the officer can safely investigate. And most Terry stops should not involve a pat-down. There should only be a pat-down if the officer thinks they're armed or dangerous. If they're detaining someone and the person's been compliant and it's not the kind of crime for which you would think they're armed or dangerous, the officer should not be patting them down, right? So we spend a lot of time on this with CPD officers, especially younger officers. We want to make sure they get this. We don't want every Terry stop to become handcuffs, patting down, because it shouldn't be, right? We want them to understand these are multi-part tests to get there. State versus Oliver, though, pat-down case. And in this case, the officer, when asked when he patted somebody down, at one point said for contraband. And our court said, well, that's not what you're doing a pat-down for. They're only for weapons. Yes?
A question on that one. So if an officer said in a situation that they were patting them down for weapons and then they found contraband, like what's the?
Yeah.
Yeah.
So, like I said, a pat-down, the only goal of a pat-down is to find weapons. However, if an officer feels an item which they know not to be a weapon, but it's immediately apparent to him it is contraband, without any manipulation, the officer can remove it. But the officer would have to say it was immediately apparent to me it was contraband upon feel. All right? And that's a tough one. You know, it depends what the item is, how big it is, but it's called plain feel. Plain feel is a legitimate legal concept. Now, sometimes it can be a tough sell for the smaller item. I mean, how do you discern a rock of crack cocaine from outside of a pocket from a big piece of dirt? All right? Usually, when officers are successful with plain feel, it's because they're patting down, they feel something, and it's an officer who's done a lot of pat-downs. They feel something, usually an item within something crinkly, something they know to be drugs in the way they're transported, so they hit it and they're like, I know that's drugs. Okay, that's usually when plain feel will come up.
Yeah, thank you.
I have a question.
Sure.
Going back to staying on Terry stops,
Yeah.
what is detaining a person too long?
Well, it's funny, there's no set time. U.S. Supreme Court in the 1980s was asked to set a bright line time. The person in that case, it was U.S. v. Sharp, said no Terry stop should be longer than 20 minutes. The Supreme Court said we're not going to do that. They can be a reasonable length of time. How do you decide if it's reasonable? Well, what are they going to stop for? How complex is it? How many people do they need to talk to? How much evidence is it? And really what they're looking at is, was the officer diligently investigating the whole time? When the officer gets to the end of what they can diligently investigate, if they don't have probable cause, they got to let them go.
Okay.
Most Terry stops are short, okay? Now, we have had some validated that are up to an hour long, depending on the amount of evidence, witnesses, and such things, all right? But generally, they're a lot shorter than that. So what you want to look at is, was the officer diligently trying to figure out if they had probable cause? And once they got to the end of what they could investigate, if they didn't have probable cause, did they let them go? Okay, like I said, they get to that fork in the road pretty quickly, usually. All right, State vs. Camper is also a new CPD case. It is a search case. Basically, what can an officer search during a Terry stop? This is an interesting case. It's one of those cases I read, and it didn't surprise me what the officer did, because it was one of those situations that was really convoluted, really confusing, and you can kind of see what happened, but the court found that the officer conducted a search they should not have conducted. Right? This guy was detained during a Terry stop. He had a backpack on him, which the officer removed from him during the stop, which is fine. And what had happened was they had seen a car wreck. The car that wrecked stops. This guy walks up to the car window, and the driver of the car hands him a backpack out the window. And this guy walks away with the backpack. So the officer confronts him as they're trying to detain the driver from the accident. He confronts this guy and says, hey, give me that backpack. And the guy says no, and eventually he takes the backpack from him, and the officer holding it says, I can smell the weed inside of it, right? He says, how did you get this? And he goes, well, my friend gave it to me from the car to hold it for him. Okay? The officer then proceeds to search the bag and finds contraband, and I don't remember what else he finds in it, but illegal stuff in the bag. And the officer, in prosecution, argued that he was allowed to search that bag because the guy had abandoned it when he handed it off out the window. And court came back and said, well, he didn't abandon it. He handed it to a friend to hold it. It's not like he threw it out into the grass. That's not abandonment. Prosecution also argued, well, it was a search incident to arrest. Well, the court said, well, the guy wasn't under arrest yet. He's being detained. And then the officer said, well, it was an exigent circumstance. There could have been a weapon or something in the bag. The court said, well, it's not an emergency once you've taken it off the guy. You should have got a search warrant. So they ended up suppressing everything found in the bag. And like I said, we expect officers to know a lot. You know, that's a lot for the officer to think through at that time. You know, what's the basis for me looking in the bag? You know, and prosecution argued all of those were valid reasons, and the court shut them all down and said, look, once you took the bag off the guy, yes, you had probable cause to search it because of the strong odor of raw marijuana coming from it, but you needed a search warrant. You didn't have any other reason to search it. So, you know, again, we put this out to officers. We spend a lot of time focusing with officers in training, think through these situations, especially once the dangerous part's over, slow down and think through what are you allowed to do and how can I do it. Vehicle stops. US v. Davis is a good case to talk about. It is also a CPD case. It's a federal case. A good case to talk about because it lays out a bunch of stuff that is confusing for citizens and gets people upset. Okay? When an officer stops a citizen for any reason, whether it's a stop sign violation or speeding violation, the officer has a legal right to order the driver and all the passengers out of the car. I think a lot of citizens will get frustrated with that. Well, you know, he stopped me for speeding. Why is he allowed to make me get out of the car? U.S. Supreme Court says officers can order everybody out of the car during a traffic stop for no reason, just because they feel like it for officer safety. Now, most officers won't do that because when you get them out of roadside, you don't know what to do with them, but you can if you want. Okay? Officers can also order people back into the car. So if people get out of the car, the officer can say, get back in the car. Again, the Supreme Court says that's okay. US v. Davis is about a half step off from that. The officers stop this car for a traffic violation. Right after they light the car up, literally a split second, the passenger gets out. Okay? And the passenger has not violated the law. It's a violation by the driver. The passenger has on a seatbelt, so no violation. Car stops, passenger gets out a split second after license sirens come on and starts walking away. The officer says, hey, get back in that car. And the guy's like, no, I didn't do anything. I'm going home. Okay, and the officer says, no, you're getting back in the car. I need you back in the car. The guy's hesitant, so the officer walks over and walks him back to the car. The car door is still standing open, and the officer can see in plain view into the car from that vantage point, guns sticking out from between the seats, right? Which leads to an arrest ultimately. The argument in the case becomes, did the officer have a legal right to order him to go back to the car, or was he allowed to just walk home? You know, what was the legal officer's authority over the passenger at that point who had exited the car and just simply wanted to go home? The Franklin County Court of Appeal, or no, the U.S. District Court, I'm sorry. The U.S. District Court said the officer had a legal right to order him back to the vehicle. What the court says is officers have a right to conduct traffic stops on their own terms for officer safety. They can order people out of the car, into the car. They can make people stay at the scene during the time of the stop. Right? Some citizens will get frustrated with this because they don't understand that authority, but it is Supreme Court authority. So here they said the officer did not violate his rights by ordering him back to the car. And then once the officer saw the guns in the car, he also smelled drugs. The officer had a reason to extend the stop. The officer had probable cause to search the vehicle, and everything kind of went from there. But the initial ordering back to the car was valid. Now, the Supreme Court says officers have unquestioned command of a traffic stop. However, that's limited. That means making people stay there and following orders. The officer cannot pat down the people from the car unless they have reasonable suspicion or under danger. So they have control to a point. Okay. State v. Oliver, the Whitehall case in the middle of page 3. Now, we're going to talk about this in a second. This was a plain smell case. In this case, the Franklin County Court of Appeals was asked, does the plain smell of burning marijuana emanating from a car give the officer probable cause to search the driver of the vehicle? And our court says no, not by itself. Okay. This is all in a state of flux now with recreational marijuana, which we'll come to in a second. We're going to spend the next year or two trying to figure out the parameters there. We're going to have to see what the courts do with it. So I'll come back to that in a second. State v. Johnson is a CPD case, middle of page 3, out of the 10th District Court of Appeals. It is an inventory case. Lots of misunderstandings with impounding an inventory, and citizens can feel very frustrated with those processes. If an officer arrests somebody out of a car, the officer can impound that vehicle. A part of that impound is inventorying the vehicle, okay, which means looking in any reasonable, accessible area in the car that could hold valuables. All right, CPD's policy is a little vague on that, but as the court says, it's within legal bounds. It doesn't say storage areas, it says reasonably accessible areas that could be used for storage. This is one of those cases. Officers are inventorying this vehicle, they get to the center console, They realize the center console is loose, kind of tilted, all the screws are missing, and you can see fingerprints around all the screw holes and handprints as if it's been lifted up and down. So the officer says, I lifted it up to look to make sure they didn't have valuables in there. And why do we inventory vehicles? To account for the valuables in the car so the person doesn't lose their stuff and so they don't make claims against us saying we lost or stole their stuff. All right? So the officer said, I thought there could be valuables under there, so I lifted it up. What did he find? A bunch of drugs, okay? He found a bunch of drugs under it. Mr. Johnson moved to suppress and said, that's not an inventory, okay? That's not a storage area. Our court said, well, it may not be a storage area, but the officer reasonably thought there could be valuables stored there, so he was allowed to look. So the court signs off on a pretty wide-ranging inventory here in Franklin County, right? And another thing with this case, and it's kind of a funny case when you watch the body cameras, the officers were certainly hoping they found contraband. And they were saying that on their body cameras. And they celebrated a bit too much when they did. All right, and after they found all the contraband under their center console, that then gave them probable cause to fully search the vehicle, which they did. They got to the dashboard, realized the dash was pretty loose, so they pulled it pretty hard. It came off, and there were a bunch of drugs under that too. Right, and once again, the court found that that was also a legal search. So, go ahead, I'm sorry.
Yeah, no, it's great. Is there, I guess, kind of the, it seems like in those situations, yes, we're doing inventory of valuables, but maybe oftentimes this can also happen. You see contraband. I mean, what is the limitation? I mean,
but it's funny. This court sets really wide parameters on it, and as long as it's an area the officer reasonably thinks could be used for storage of valuables, it can be looked in. And what the court really, the line is, you can't break stuff. You can't cut up the carpeting. You can't look under the hood, in the trunk, or you can't look in the trunk, not under the hood, in the gas tank. You can't cut up the carpeting, cut the seats. But if an area's been disassembled in a way that it appears storage has been there, you can look. And officers are used to that. There's certain parts of the car people will take apart to hide things. You know, the center console being one of them, the parts of the dashboard. And usually officers will push on it to see if it's loose, or they'll look to see if all the screws have been removed. Okay. And here, the center console had every indication it had been taken apart many times and removed. And in fact, the officer kind of hit it hard, and it just fell off.
got it.
You know, and it was funny when it said I tapped and it fell off. You know, I immediately looked at the body camera. I'm like, no, it did. So, and there were there was a reasonable belief that there were valuables there. You know, officers find valuables in cars in a lot of weird places, to be perfectly honest. People store money in their in the guide to the car. You know, so they'll like do that to make sure they don't leave $100 in the car.
Got it.
So, yeah, a pretty wide-ranging policy, though. And generally what the court will say is as long as you're within your policy, it is legally reasonable in the Fourth Amendment. Okay.
Thanks.
So permitless carry-in stops and recreational marijuana. These are two big things for law enforcement that I think you're going to see play out over the next couple of years. They're going to impact how law enforcement deals with people during street-level Terry stops and during traffic stops. Permitless carry went into effect in June of 2022. And what it says is any qualified adult in Ohio, any qualified adult can carry a concealed handgun as long as they're not in a prohibited place, right? It really flips the entire law. It used to be in Ohio, the presumption was you were not allowed to carry a handgun unless you got a permit. Now the presumption is you're allowed to carry a handgun unless you have a disqualifying incident or offense. The difficulty with it is, it used to be when an officer stopped somebody, especially during a traffic stop, they will have run them on leads, and they would have seen they had a permit for the gun, which means they were trained, had a permit, and didn't have a criminal record preventing them from having the gun. So the officer had a lot of predictability with those stops. Now, you're not going to know that. Because you don't have to get a permit, you're not going to know that. You're not going to know enough about their criminal history, you're not going to know anything, and they're not going to have the training on how to act. So you're going to have more uncertainty in these stops is what you're going to have. And that's a fact, and we've seen that already at CPD where we've had some situations where there's confusion. The other part of this law that makes it more difficult, under prior law, if someone was carrying a concealed handgun, they had to proactively tell the officer upon contact, I have a permit, I have a gun. Again, that would make it a more predictable situation where everybody knew what was going on. They've removed that requirement, okay? However, and we've went right to this with training, so you know, if the officer asks these people if they have to have a gun, they have to tell the truth. So we've told officers during every single stop, one of the first things out of your mouth should be, do you have a gun, do you have a firearm on your person or in your car now? They have to tell the truth if they're asked. They don't have to proactively announce, but they got to tell the truth. So you should see that showing up all the time in stops now to try to deal with this issue. It's still hard, because an officer's going to stop somebody, they're not going to know much about their criminal history or not enough, so you're not going to know if they're a disqualified adult. You may not know at all, or it might take a while to figure it out. And the list of disqualifiers is long. There's many, many disqualifiers that an officer will have some trouble navigating during these kind of stops, because these kind of stops are short. So it makes it more difficult to know if someone should legally be carrying a gun, to be honest with you. So we've been trying to keep an eye on those, and we keep talking about them in training as we see incidents. Recreational marijuana, you know, I don't know how this is going to play out over the next couple of years. It makes it legal in Ohio to grow, carry, possess certain amounts of marijuana, okay? You can have 2.5 ounces of adult use cannabis in any form except adult use extract. You can have 15 grams of adult use cannabis in the form of adult use extract if you're 21 years or older, okay? So it used to be if an officer stopped somebody and smelled raw marijuana in their car, you had probable cause to search the car because that's illegal. Now we don't know, because you are allowed to transport a certain amount of raw marijuana in your vehicle now. So it does change a lot of this. Now, how much we don't know, because marijuana is still illegal under federal law. All right, so there's that. Also, you're not allowed to smoke marijuana in your car. No one's allowed to smoke marijuana in the car, so if it's burning marijuana, that still is illegal in a vehicle. So, but we don't know how this is going to play out. We don't know how it's going to affect the ability to search vehicles or search people. We just don't know at this point. We've looked at the other states that have regulated marijuana, or recreational marijuana, and they're kind of all over the place, to be honest with you. So we're going to have to kind of take this step by step on how it impacts officers. Yes.
Do you have any insights on what, you talk about other states, like insights on maybe best practices or policies from police departments in these situations?
Yeah, we're working through that now. We have a training, in fact, next month with our K-9 unit, because this impacts the use of K-9s on vehicles. We're sorting through that now. We're trying to take it one step at a time, to be honest, for a lot of reasons. One, because we don't know for sure. In like some states, I want to say Colorado, they've simply said that odor marijuana no longer gives you probable cause to do a search. Other states have not went that way. So there's a certain lack of predictability. Here's the problem.
Got it.
So, and we also, you know, there's been a lot of talk that the feds will at some point legalize marijuana. I don't know if that will happen or not. That would make this a little simpler, to be honest with you. The legislature in Ohio keeps talking about making some changes to this, but they have done nothing at this point. So we're still kind of in limbo on some of these issues. We have told officers, and you can see that in the legal update, I believe. We've told officers that searches or detentions based on marijuana should be based more now on the totality of the circumstances, not odor alone, because we think the courts will probably move more in that direction over the next year or two. So we're trying to get officers more conditioned to that being a factor, but not the sole factor supporting a search or detention.
Got it. Thank you.
So, but again, though, my guess is we're going to be putting out legal updates every few months saying, oh,
Yeah.
here we are now.
Yep.
So home-grown marijuana is legal now. You can, one individual can grow 6 plants in their house. If they're 2 adults, they can grow 12 plants. 12 plants is the cap, though. So 12 plants, it has to be hidden from public view. There are limitations around kids. And bear in mind, you're not allowed to smoke marijuana in a car or any public place. Mm-hmm. Any more questions about that?
There hasn't been any policy changes for CPD with regard to stopping.
No,
Right.
no policy changes at this time. We're kind of slowly looking at that, talking to the division, but no policy changes at this time. And we've told them not to make any radical policy changes till we have a better sense for how this will play out. Arrest, probable cause decisions, arrest processes. Probable cause is pretty straightforward. I mean, a lot of these legal, in fact, most of these legal standards haven't changed in a long, long time. Now, we see the courts messing around the edges of it, but they don't change. Probable cause is defined as reasonable grounds for belief supported by less than prima facie proof, but more than mere suspicion. Probable cause is more likely than not. When I teach young officers how to decide probable cause to make an arrest, I usually say, look, you got to look at the facts, the totality of the circumstances, all the facts, and you got to look at the criminal code section you're going to cite them for, charge them for. Do you have facts to support each element of that crime? That's probable cause. You know, it's more likely than not you can prove each element of that crime with the facts you got. And we usually do that by example with them going through various crimes. Generally speaking, if a person claims they were wrongfully arrested, they would have to show there was a lack of probable cause based on what the officer knew at the time. One thing at the bottom of this case, Davis versus Wallaman on page 4. There's no constitutional right to refuse to identify oneself during a lawful Terry stop. I think citizens and officers can get sideways with each other because citizens don't understand their rights and officers don't always take the time to educate them. And we talk a lot about that. Stop and ID law is what's here. There's a law in Ohio that says when you're stopped for a Terry stop, meaning there's reasonable suspicion to stop you in a public place, if the officer asks you for your name, date of birth, and address, you have to give it, right? A lot of citizens don't understand that. You know, say, well, I got a Miranda right, I don't have to talk, or I've got a legal right not to tell you who I am. That is not true in Ohio. Under the stop and ID law, if you are legally stopped, you've got to give your name, date of birth, and address, and if you don't, you can be arrested. And that's what happened in this case. He got arrested, said I had a constitutional right not to disclose my identity, and our federal court says, no, you don't. Right? You have a federal right not to incriminate yourself, but your identity by itself is not incriminating. So we talk to officers about this. A lot of citizens just don't understand these issues. And we'll talk to officers about slowing down and explaining to people, hey, you've got to tell me that stuff so I can take your report, and if you don't, I can't arrest you. We'd rather those arrests not happen and that people understand they do have to produce that information. Yes?
You said legally stopped, so an officer can't just,
Right.
like, walk in an alley,
Right.
ask for your name,
A
address.
couple of things with what you said there. So one, it has to be a valid Terry stop in a public place for stop and ID to apply. It does not apply to consensual encounters. We've seen in Ohio, we've seen some cases where officers arrested people for failing to produce identification in a consensual encounter. Citizens don't have to do anything during a consensual encounter. They can tell you to get lost. They can refuse to produce identification. So you have to have reasonable suspicion and a detention to get that in a public place. One thing with that, we've talked to citizens and student groups about this. If you don't think you're being legally stopped, but the officer does, that's not the time to have that fight, okay? You should be thinking, well, I don't think the officer had a reasonable suspicion. I won't tell him anything, okay? You should give them the information if the officer believes they legally stopped you. Now, if you want to have a fight about what if they should have done that, we can have that later on. Don't have it right there. I mean, you may be wrong. Maybe the officer's wrong, but you may be wrong too. So if the officer says, hey, look, you've got to tell me your name, date of birth, and address, then you should produce that, and we can sort out the legal part of that later, if that makes sense. All right, middle of page 4, a few things with arrest. I put these sections in here just so you can kind of understand what we talk about with these issues. Officers need to understand when they can arrest people, when they cannot arrest people, and when they have to arrest people. In Ohio, if a crime is on view, meaning the officer saw it happen, and it's an arrestable offense, the officer can arrest, meaning take that person to jail. If it's an on-view offense, we call that on-view or found violating. Okay, it says they can be arrested. There are a certain number of offenses that officers are not allowed to arrest for unless they see it happen. Criminal trespass, criminal damaging, disorderly conduct, those kind of things. Generally, non-violent misdemeanors. Those kind of offenses, the officer cannot take the person to jail unless they see it happen, right? And then there's a whole bunch of other offenses like domestic violence where the officer essentially has to make an arrest if they have probable cause, even if they didn't see it happen, right? There's a whole range of offenses like that. 293503 is the found 293503 is the found violating part I've got in here. And then the domestic violence portion. In Ohio, the preferred course of action on domestic violence or protection orders is an arrest if there's probable cause. So if you ever wonder, hey, why did the officer choose to arrest that guy? It may be that they're supposed to. Domestic violence, violation of protection order, those kind of things, the officer essentially has to make that arrest and take the person to jail if there's probable cause. And if they don't, they have to do a written statement explaining why they didn't. And to be perfectly honest, we tell officers we rarely see a good reason to do that those people should go to jail. All right. If you wonder why an officer didn't make an arrest, we will get complaints about that. Someone will say the officer didn't do anything. They didn't make an arrest. It could be that they weren't allowed to. For example, criminal trespass can be really frustrating to citizens. You know, you own a business. You have a chronic trespasser who comes in your business. They've been trespassed. You've given them a letter saying you're not allowed in here, don't come here. They come in, they trespass on a given day. They cause trouble in the business. You call the police. It will take the police a little while to get there sometimes because trespass is not a high priority run. The officer gets there in a half an hour. Where's the trespasser? They're gone. So the officer goes down the street and talks to him, goes back to the business and says, hey, I can't take him to jail. I didn't see it happen. Okay, and that will be a frustrating thing. And the feeling the citizen will get is the officer didn't do anything. So bear that in mind. There are rules for when they can and can't arrest and when they have to arrest. If you ever have questions, you need to look at these statutes. The new strangulation or suffocation statute went into effect back in April. It essentially made any strangulation or suffocation a felony in Ohio. So it basically took 400 misdemeanors or 400 cases that were misdemeanors a year ago and made them all felonies now. So any strangulation or suffocation, which is defined as any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose or mouth, is suffocation or strangulation. These would have been misdemeanors a year ago. Now these are felonies in Ohio. Right? It was a change for us. Like I said, first of all, it was just a whole lot more felonies, which means a lot of things. We had to train officers on this. We had to create a group of officers to do this enforcement because we don't have enough detectives to cover another 400 to 500 felonies all of a sudden. So patrol officers were trained to handle these cases. And this whole system is still playing out as we try to figure these out. So these are all going to the county prosecutor now. Any questions about the strangulation or suffocation? It is, yes?
Filing the strangulations as felonious assaults before?
Sometimes. Yeah, I would say not that often, but sometimes. Most, what we're seeing is, I hate to say it, we've been minor strangulations were filed as misdemeanors. So unless there was significant, meaning serious physical harm, they were getting filed as misdemeanors. So unless the person was passing out or being taken to the emergency room, they were being filed as misdemeanors, which meant about 95% of the time probably.
So now they're all going over as
They're all going over as
felonies.
felonies. And what level of felony depends on level of harm and if it's a household or family member or not. So it's an F4 all the way up to an F2. So it kind of depends on the level of harm and who it is. There are a lot of domestic violence strangulation cases. So those are resulting in arrest on a felony, higher bonds, all that kind of stuff. So if you see that, that's why that's happening. Top of page 5, another new CPD case. This is a search incident to arrest. When an officer arrests somebody, they can search that person, everything within their immediate control and everything on them. It is a full-scale search of everything, if you see that. Use of force. A couple of things with use of force. Cunningham versus Packard is a new federal case. We mostly look at the Sixth Circuit for our use of force cases. That's generally who we listen to, who we look to for guidance. And Packard is like 1,000 other cases. It walks through the Graham versus Connor standard in the middle of page 5. The Graham versus Connor standard has regulated use of force in America since 1989. What's the Graham versus Connor standard? Whenever there's a use of force, we're going to look at 4 factors. What was the crime at issue of the use of force, meaning was it serious or not? Was the person actively resisting arrest? And the critical word is actively resisting arrest. Were they evading arrest? And were they a danger to the officer or others? And we're going to balance that out and say, was it a good use of force? Was it a reasonable use of force under the Fourth Amendment? Looking at those 4 factors. The more serious the crime, you would think more force. Okay? Not always true. You could have someone getting arrested for a really serious crime who's fully compliant. That's going to be no force. Occasionally you have people arrested for pretty minor crimes like an M4, and they all of a sudden actively resist. You'll have more force. We balance it, though, and look at those 4 factors in deciding if a use of force is reasonable under the Fourth Amendment. That is in every use of force policy in the country. It's in ours. Right? It's in 201. And a couple of things in this case. The right to arrest carries with it the right to use some degree of physical coercion. The critical phrase is active resistance. And generally speaking, there's a case in here that says it. It's pretty straightforward. If there's active resistance, force is reasonable. Some force is reasonable. If there's not active resistance, generally force is not reasonable. That's kind of the dichotomy. What is active resistance? We know the classic active resistance, pulling away, hitting, fighting, that's active resistance. It also could be threatening, or it could be them doing something that's dangerous. But generally speaking, one thing I try to tell officers, if what a person is doing is not dangerous to you, it's probably not active resistance. So is it dangerous to you as an officer during the arrest process? If it is, it's probably active resistance. 99% of active resistance is the classic pulling away, hitting, kicking. You do get occasion where someone's non-compliant and their non-compliance is dangerous. For example, they won't show their hands and you have reasonable suspicion they have a weapon. They're being passive perhaps, but that passivity in that circumstance is dangerous. Generally speaking, though, if a person is just simply being non-compliant and it's not dangerous, that's not active resistance, and that should not involve the use of force. So again, we wrestle around with the whole active resistance thing a lot. Ms. Burns had asked about taser use, to talk about that. A couple of things with taser, mace, pepper spray, all those things. The Division of Police divides them up by level of force. Have you seen the division level of forces? It's a level of force that goes from level 0 up to level 8. It categorizes type of force by level. Use of mace is a level 2 use of force. Use of taser is a level 3 use of force. So the division rates a taser as a higher level of force than mace. Striking is a little bit higher than that. So they categorize them that way. Willard, do I have them right more or less?
Sir, I didn't remember.
Okay. So
0 and 8.
So here's the thing. So the courts don't do it that way. The courts are going to look and say, was the person actively resisting? Yes. So some amount of force was reasonable. Some amount of non-deadly force was reasonable. They don't get into, well, you should have maced them instead of used the taser. You should have tased them instead of striking them. Basically, they're going to look and say, was non-deadly force reasonable? If it was, then non-deadly force is reasonable without splitting hairs. The division divides them up more by policy. All right, so occasionally I'll be asked legally, how do you feel about the taser versus mace or pepper spray? Like, legally, they're not different. Okay, they're both used as a non-deadly force, and if non-deadly force is reasonable, a court's going to look and say, we're not going to pick which use of force which we think is best. We're just going to say any non-deadly force in that situation was reasonable. Right? The division, on the other hand, has their levels of force, which guide an officer when to use force and what it's looked at, how it's looked at. Yes.
I got a question on that, because right here it mentions the appellate court here considers the force used not the extent of the injury inflicted.
Correct.
In an excessive force analysis.
Right.
What about like environmental factors, right? In the sense of like, whether you're on concrete or
Yeah,
something.
absolutely,
Yeah.
yeah.
How does that get into play?
That's all within division policy. I'll get to in a moment. Yeah,
Okay.
it's in policy. The courts do talk about that too. They're going to look at all those factors to decide if the use of force is reasonable. If it could be situations, for example, if someone's climbing over a high fence and tasering them would cause them to fall off the fence onto their head, that would be a factor in deciding if it was a reasonable use of force. What they're saying in that case, and I've had these cases before, is sometimes the injuries can be disproportionate to the use of force without any fault of the officer. I had a case once where an officer shoved somebody really hard to get them away from them. The person took an extended stumbling fall, ended up falling over a bench and breaking their leg. It was an unforeseen consequence of the shove. So on that, the use of force was perfectly reasonable. The person had a significant injury, and we thought the use of force is still reasonable at that point, even though you had this surprising injury as a result of it. So, it's a balancing, but the court's going to look at all those factors.
Okay.
And I'll get to the policy here in a second, which really looks at that. But what you'll see is, use of the taser is permissible where a suspect poses an immediate threat where they're actively resisting. This bottom of page 5, Shoemate versus Akron. Going over to Goodwin versus Painesville on page 6. Even previously resisting suspects have a constitutional right to be free from gratuitous application of the taser. Okay. So when we're looking at use of the taser especially, here's a couple of things we always remind officers. It has to be reasonable at the outset, okay? You have to have active resistance or danger to use it initially. If you deploy it more than once, each time you'd have to cite there was active resistance or danger. You couldn't say, they were dangerous, so I tased them 4 times, okay? It'd have to be, they were dangerous, I tased them, they continue to actively resist, so I tased them again. Okay, so was it reasonable at the outset, and did you continue to use it in a reasonable manner? And one thing the courts say, and this is a really hard one for officers, but they know this, it's hard to turn the force off when the resistance stops. If you have someone who violently resists for an extended time, and all of a sudden they stop and give up, sometimes officers have trouble stopping at that point. Because it's scary, it's dangerous in the heat of the moment. That person may have endangered the officer, but, it's hard, but they're trained, the force has to stop when the resistance stops. So if you tase someone because they're actively resisting, and then they stop, well, then you don't tase them again. It stops at that point, all right? And that is a constantly difficult issue to be perfectly honest, because if there's a lot of fighting going on, sometimes it's hard just because of human nature to stop. But that's something we have pounded home every training I've ever done because it's difficult, especially with the taser, I think, or with physical force. There are pepper spray cases in here. The courts don't look at pepper spray any differently than mace, like I said, or the taser. Is there active resistance, and did you use it while they were resisting, and did you stop when they quit resisting? Is how they're looking at these mid-level uses of force, these non-deadly uses of force. A state of Irwin versus Greene County. This case relates to the question Ms. Burns asked me and relates to the policy. What about using the taser on older people, obviously pregnant females, children, people with disabilities, or against people on a dangerous surface, perhaps? Again, those are largely policy decisions. The court's still going to look at it with the same test. Was it reasonable given the circumstances? Was the person actively resisting, or were they a danger to others? The state of Irwin versus Greene involves an elderly woman. I think she was 81. She was approaching officers with a metal rake held up at them. They ordered her to drop the metal rake repeatedly. As she got close enough to strike them and seemed to be moving toward them, an officer tasered her, which caused her to take a bad fall. Her estate filed suit saying that was an unreasonable use of force because of her age, and the court did not agree. The court found that it was a reasonable use of force, that she was an immediate threat to the officers, and the court said there was no evidence that the woman was not capable of swinging or thrusting the rake at the officer. So they considered it, but said, given the circumstances, she was a danger to the officers. So what we get from this is there's no prohibition against using the mace or taser against those people. There's no prohibition against using the taser against older people or children or people with disabilities. The court's still going to say, in spite of their disability or their age, were they a danger to the officer at that time? Okay. Now, policy absolutely requires officers to consider that stuff. If you look at Division Directive 204 at the bottom of page 6, it's is the chemical spray directive. It says sworn personnel may use chemical spray to protect themselves. Okay, may. Okay, sworn personnel should not use chemical spray on handcuffed subjects. Okay, if you know police language, okay, there's a difference between shall and should not. Okay, which I think can be frustrating to people, and officers completely get this when they read it. Should not doesn't mean you can't do it. Okay, shall not means you can't do it. Should not means you shouldn't do it, unless you have to. So they're not supposed to use chemical mace on a handcuffed subject unless they pose a danger to themselves or others. We do have occasions when people are in the back of cruisers, they are handcuffed in the back of the cruiser, and they start kicking out the window, they start banging their head against the screen, or they start spitting through the screen onto the officers. Okay? At some point, even though their handcuffed use of mace may become reasonable in that circumstance. I mean, generally speaking, though, they should not be using force against a handcuffed suspect. Yes.
But because that says should not shall not, I mean,
Right.
what is the actual violation? I mean,
Well,
it's
an officer would have to justify why they did it. Because
Yeah.
what the division is really saying is, you shouldn't do this unless you can give a specific reason why it's reasonable in this circumstance. But generally speaking, we don't think you should do this. So it creates the burden on the officer to explain why they did it.
Okay, got it.
Yeah, so the shall nots are different. The shall nots are prohibitions. You look down, sworn personnel shall not use chemical spray to disperse a congregation of individuals. What they're saying is, and some of this came out of the protest in 2020, that officers shouldn't use mace to move a crowd or disperse people, because what ends up happening is you have some people who maybe are breaking the law and some people who aren't, and you end up macing all of them. So the directive's been tweaked to make sure that if you have a lawbreaker in a crowd, you're targeting that person, not just the crowd. It makes it more difficult, but it is compliant with the law. Sworn personnel encountering a group of people, some of whom are engaged in unlawful contact, shall be guided by the use of force directive when deciding whether to use spray. Again, trying to avoid using it when you're going to hit innocent people. If chemical spray is used, it shall be directed to the persons participating in the violent conduct. So making it more of a requirement that when you use mace, you're only targeting someone who you have probable cause to arrest, as opposed to just people near them. Moving over to the top of page 7, this is the taser directive. Again, you get the should not, shall not language. Sworn personnel should not use an intermediate weapon on a handcuffed subject. Again, no intermediate weapon should ever be used on a handcuffed suspect unless you can explain why they're still dangerous even though they're already restrained. Sworn personnel should not target the head, face, neck, or groin with a taser probe, okay? So the only time you should do that is if it's an exigent circumstance, meaning you just can't help it, okay? Sworn personnel should not intentionally target the chest area above the sternum when using the taser in probe mode. Again, it's not an explicit prohibition, but you're not supposed to do that unless you have no other choice. Sworn personnel may target the neck or groin with the taser in drive stun mode, meaning not with the probes, because it's less dangerous. Sworn personnel shall consider training in the following when deciding whether to use the taser: the subject's age, their weight, their obvious physical disabilities, okay? Subjects who are in a position where a fall may cause substantial injury or death, or mental illness. So what they're saying is, you're not prohibited, but those are times when you should consider whether to use it, and you shouldn't use it if there's a danger associated with those if you have other choices. Sworn personnel should not use a taser in drive stun mode for pain compliance if it is likely to be ineffective due to intoxication or to signs or symptoms of mental illness. Taser International will tell you the taser does not work on people with a mind-body disconnect. That's what they call it, a mind-body disconnect, which could be intoxication, mental illness. So if you use it in drive stun mode with someone who's mentally ill and it doesn't work, you should quit using it. Okay, there have been cases from around the country where officers did use it in drive stun mode repeatedly, and the person died. So basically, if it doesn't work on someone and you have reason to believe they're mentally ill or intoxicated, you should use something else. At that time, you shouldn't use the taser again. Should not use a taser on small children, infirm, or elderly individuals, obviously pregnant females, or subjects who are in control of a motor vehicle. Again, it's a should not. Officers are trained not to do that unless there's simply no other choice. Shall not use it if someone's exposed to flammables because it will catch them on fire. Shall not use a taser on a fleeing subject who has committed only a minor misdemeanor. So this was a policy choice made years ago. What we found was, people would flee from a minor misdemeanor, like a jaywalking. They would run. That does become an arrestable offense when they flee, but the division said, we don't want you to use the taser on those people, even though they are committing an arrestable offense in fleeing, because what we found is the amount of injury occasioned by that is not worth the use of the force. Right, so they just simply said, if your probable cause initially was that minor misdemeanor, we don't want you to tase them, even if they committed an arrestable by running. It's just not worth it to us. And a phrase that gets used in policing a lot, the juice is not worth the squeeze. We were hurting people who were running from a jaywalking stop. And, some officers would argue, well, if they're running, they must have a good reason to run. They've got a gun, they've got a warrant. We weren't finding that. People ran, but who knows why, but there was no underlying obvious reason why they were running. Deadly force directives down here, not down here, it's in 201. Deadly force standard hasn't changed since the 1980s. Tennessee v. Garner is a deadly force standard. An officer has to have probable cause to believe that the suspect poses a threat of serious physical harm either to the officer or others to use deadly force. Straightforward, probable cause is the standard. The CPD directive has a bunch of different things in it that regulate the use of deadly force. You have to give warning when you reasonably can do so. You shouldn't shoot at moving vehicles when you reasonably can get out of the way of them. There are a bunch of different limitations on it, but it is generally, it tracks the probable cause standard. Over on the top of page 8, I'm going to run out of time here in a few minutes, I can see. Warrantless arrest. Home entries are obviously a font of constitutional arguments for police departments. When can officers enter a house? When they got consent, an arrest warrant, a search warrant, or an exigent circumstance. If they don't have one of those 4 things, they should not be going in the house, all right? Even if they have probable cause to make an arrest, they should not go in the house unless they have probable cause and a warrant or an exigent circumstance. So we tell officers you ought to have a menu in your head when you're at the door of a house. You should be thinking, okay, what gets me in the door of a house? Search warrant, arrest warrant, probable cause, search warrant, arrest warrant, exigent circumstance, or consent. If you don't have those things, you shouldn't go in the house. And you think, well, I got probable cause to believe they broke the law, I can file a charge. Go get an arrest warrant then. At that point, you don't go in the house to get them without the warrant unless there's an emergency, which there generally is not. And this applies to everything. It could be probable cause to arrest for a felony. If it doesn't rise to the level of exigent circumstance, though, you're still getting that warrant to effect the arrest later. It's not a home entry. Home entries are difficult. They're difficult for everybody, they're upsetting, the Fourth Amendment protects the house like nothing else, and if you're an officer and you're standing at the door of the house looking in the screen door and you see the suspect for whom you have probable cause to arrest, it's hard to think, why can't I just walk 5 feet and get him? Why do I have to go get an arrest warrant? It will take 2 hours, we're gonna have to guard the house. Why can't I just get him right now? That's a tough one. We spend a lot of time with young officers. Know when you can cross that threshold. It doesn't matter if it's a door even. The minute you cross that threshold, that is a Fourth Amendment entry you have to justify, any crossing of the threshold. And like I said, that's hard. I've had many things over the years where an officer says, I was on this side of the door, they were on that side of the screen door, they were 3 feet from me, I just opened the door, grabbed their arm, I'm like, that's an entry. That's an entry, and it was a bad entry because you didn't have an exigent circumstance or a warrant. All right, so we spend a lot of time on that. Execution of arrest warrants, officers have to knock, announce, wait a reasonable amount of time. The officer has to have reason to believe the person's home at the time and reason to believe that is in fact their residence, which is usually evidenced by their address being on the arrest warrant. Officers should understand this. This is also in the city code. Have to knock, announce, wait a reasonable amount of time. What's a reasonable amount of time? Depends on how big the structure is, the time of the day, all that kind of stuff. How long would it take someone to reasonably come to the door? What's the philosophy on arrest warrants of knock and announce? We want people to be given the chance to come out and peaceably surrender on their own instead of an officer having to force entry and go in their home, if we can avoid that. Again, hard to be patient sometime when you can see the person in the house. Consent, officers can ask for consent to enter a house. People consent a lot of the time. You know, who can consent to an entry in the house? Somebody with joint authority, control of the house can consent to an entry. You know, can children consent to an entry? They usually can if they're old enough to freely, voluntarily give consent. An older teenager could consent to the police entering your home. Okay, they could not consent necessarily to them looking in your personal stuff, but they can let them in the house. Officers will ask for consent to go in homes if they think they can get consent freely, voluntarily given. Hot pursuit, very quickly, hot pursuit changed in 2021, all right, in the Lang versus California case. It used to be if an officer had a hot pursuit, meaning they started trying to arrest someone outside, that person ran and the officer chased them, the officer could automatically go in the house and get them. Not anymore. Lang says if the probable cause for the arrest is a misdemeanor, the officer would have to articulate another exigent circumstance to enter the house. What the Supreme Court says is we don't think a hot pursuit for a misdemeanor is automatically an emergency all the time. For a felony, it is. For a misdemeanor, maybe. You'd have to articulate why you think that arrest is that important to run in the house after them. So this has changed the rules for officers and took some retraining. I'm going to skip over for a couple last things here because I'm out of time. Need to render aid. We've had complaints and lawsuits both ways on this. An officer can enter a home if there's an exigent circumstance in the home. An exigent circumstance just means there's an emergency in the home and there's not time to get a warrant. A lot of the times when our officers are entering homes on an exigent circumstance, it's because they're going to render aid. They reasonably think somebody inside the house is in danger or needs aid. This comes up a lot with domestic violence runs, where officers get out on a domestic violence run and they believe the victim is in the home and is in need of aid because of the nature of the call and what they're hearing or seeing at the scene. This also comes up on wellness checks. Somebody will call in and say, hey, I'm concerned my son is suicidal, will you go check on him? And the officers will get to the door of the house and have to decide, do I have enough information? Do I have enough information to believe the person inside needs my aid perhaps or needs me to protect them? The officer can make a forced, non-consensual entry if they have reason to believe the people in the house are in need of aid. Reed versus Campbell County is a brand new federal case on that. It was a domestic violence run where the officer ultimately made a forced entry and the court said the officer did not have enough information in that case to do so. All right? So we talk about this a lot, and I will tell you flat out, I would tell officers, if you think you have reason to believe the people in the house need aid, err on the side of making the entry to check on them, because it's almost a half step off of policing. You're not entering for crime fighting, you're entering to help people and check on them. So if you think you have reason to enter to give aid, go ahead and make that entry. It's a limited entry, only to check on people. If you quickly figure out you're wrong, then you leave. But we do have these entries made pretty frequently. We've had people complain when we make the entries, okay? We've had people complain when we don't make the entries. You know, we've had both, yes.
Thank you for that. And what, is there a particular kind of policy around, like medical, if maybe an officer's there with medical staff, like what's the, is
Yeah,
there
I
any
mean,
sort of?
again, as you know, there are 3 or 4 words that get used, phrases or words that get used all the time. That one is going to be totality of the circumstances. Based on the totality of the circumstances, does the officer have reason to believe someone needs aid? It could be talking to medical people. It could be talking to family members. It could be the nature of the call. It could be all kinds of stuff. Like I said, these come up a lot on DV runs, domestic violence runs, because, you have a female caller call in and says, my boyfriend's beating me up. There are signs of violence in the call. You get out there, boom, 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 boom. Nobody will answer the door. You go to the neighbors, so they're in there. They were fighting right before you guys pulled up. They're in there. Okay, he beats her up all the time. Would that give you reason to think she might need aid? Yeah, and the officers are gonna knock. They're going to try to get the person to answer the door. If they can't, they're going to kick that door in and go in the house and see if she needs aid. Okay, you're looking at the whole picture to decide if somebody inside needs aid or not. These entries are controversial both ways. Sometimes people get mad because the officer kicks the door in and does some damage kicking the door in. We've had times when officers didn't make the entry and we later on found that someone was seriously injured inside. So these are tough ones for the police. We talk about these a lot because they're hard. Searches instant to arrest. Once an officer is in a house and makes an arrest, they're allowed to do searches and sweeps in the house. US v. Riley, the middle of page 9, is a new CPD case out of federal court. This involved an arrest on a domestic violence, where the officer did a protective sweep in the bedroom where the person was arrested and found guns in the closet, which were used against him to prosecute him for federal gun charges. He moved to suppress and said the officer should not have looked in the closet. And there were 2 officers sweeping, and they spent too long doing the sweep, and the federal court said they're allowed to spend, they should be quick, but they're allowed to spend a reasonable amount of time looking in any place that could hold a person at that point. And the closet was such a place. So it was a good sweep. So even though they weren't looking in that closet for guns, they saw the guns in plain view during a protective sweep and were allowed to use them against him in the federal gun case. So these sweeps, searches happen in houses. They can be upsetting to people. Finally, over on page 10, a couple of things Ms. Burns asked me to talk about. Miranda warnings. Citizens are always confused about their rights when it comes to Miranda warnings or these things. When does an officer have to give people Miranda warnings? Okay, when they're in custody and being interrogated, all right? How often do you think CPD interrogates, how often do you think CPD reads suspects and their Miranda rights? How often? A lot, a little? How about hardly at all? Okay, and why is that? Because the vast majority of the time, people incriminate themselves before they're in custody. We only have to give people the Miranda warnings once they're in custody and being interrogated. A lot of people will interrogate themselves well before they're ever in custody. What will happen is, like on the domestic violence run, which I use as an example, and why do I use it as an example? Because it's a good one, and we had about 30,000 DV runs last year, so it's a constant, okay? Officer goes out, female half who's called is in the front yard. She's crying, disheveled, her eye is swollen, clearly been hit in the face. She points up, says, my boyfriend up on the porch beat me up. He punched me in the eye. We're living boyfriends, we have a child together. Okay? He throws his hands up. The officer says, hey, come on over here, let's talk for a second. Let's separate in this chat and find out your side of the story. He's not in custody at that point. The officer says, what happened? Okay? He says, well, she says I hit her a bunch of times. I only hit her once. Okay? What do we got there? We have probable cause to arrest him at that point. Domestic violence is knowingly cause or attempt to cause physical harm to a household or family member. Do we have probable cause to believe he did that? And he's a household, yeah. So he's getting arrested at that point. He's incriminated himself, given us probable cause without ever being in custody. So he's probably never going to be Mirandized in that situation because he was not interrogated while under custody. So that's why, I mean, a lot of citizens will say, I got arrested by CPD. I didn't get Mirandized. We're like, well, okay, did they interrogate when you're in custody? Most citizens aren't going to understand what that means either. They think whenever an officer talks to them, that's custodial interrogation. It is not. Roadside questioning is not custodial interrogation. So if you get stopped for a traffic violation, they get up to your car window and they smell alcohol and start asking you questions. You've been drinking, where you been? That's not custodial interrogation because sitting in your car is not custody. A Terry stop is not custody. If an officer stops you at street level, it's typical at street level Terry stop, and they ask you some questions about what you're doing. That's not custody, so they don't have to Mirandize you. So the vast majority of police-citizen interactions aren't custody. That's why Miranda warnings aren't given. Usually if we're doing Miranda warnings, it's because the person has been arrested, taken to headquarters and is being interrogated by a detective. That's usually when we're seeing Miranda warnings at CPD. It happens in the field some, just not a lot. Any questions about that? We get a lot of issues about Miranda warnings because citizens don't understand that issue. They don't understand their rights. There are some newer CPD cases here, a lot of litigation about Miranda warnings. The last case, US v. Jacobs, is a CPD case where our detective threatened somebody during a interrogation, and he threatened them with a search warrant. Jacobs is an interesting case out of our federal court. The officer had arrested this guy. He was in an interview room at headquarters of CPD across the street, and he was a suspect in a series of Walgreens robberies. And he had on the same clothes in the interview room that were on the video in the robberies. He had on a face mask, but he had on exactly the same clothes. And in fact, he had a giant food stain on the front of one of the shirts that was exactly what was in the video. And he told the detective, yeah, I don't know anything about any of that. I don't know. And the detective said, I'm going to go do a search warrant on your house. Okay, he lived with his dad. I'm going to do a search warrant on your dad's house. We're going to toss the whole house, and we're going to find those guns. And the guy then confesses. And he said that was coercion, that you're not allowed to threaten people during a custodial interrogation. The court said, as long as it's true, you can. And he had probable cause to get a search warrant, which he was going to do, so not an unreasonable threat in the course of that interrogation. So we have a lot of case law on interrogations. It's a constant area of litigation. That's what I have today. I don't know what other questions you have. It's hard to cover the issues that CPD has in an hour. I mean, we have thousands of legal issues all of the time. And one thing that I always, when Alexis took this job, I always joked about it. People will ask me what a typical day looks like. I'm like, oh, there's no typical day. I come in thinking I'm going to get something done, and then 5 hours later, I'm sorting through some weird question about who knows what, just because that's the nature of policing. It could be I'm getting a weird question about parking tickets, and an hour later, I'm getting a weird question about a search warrant on a homicide. The legal issues are constantly coming at officers. There's a lot of weird issues that come at officers. If they're calling me in the middle of the night, it's usually because of something weird. They're not going to call me if they know the answer. Okay, they'll call me about something weird, and my wife will laugh, and I'm getting called in the middle of the night. She's like, who would know that? I'm like, well, not me. And usually I'm like, officer, hold on, give me about 15 minutes to pull my laptop up and I'll call you back, okay? Because it's a difficult job with a lot of legal issues.